Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions in the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. On this show, I interview lawyers ditching the billable hour and experts who can help attorneys move beyond billing time. Thanks to my sponsors, 650 and Gavel. Links to both in the show notes. More on them later, and use the code LAWSubscribed when signing up. You get 10% off, and it supports the show. The best way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. I'm thrilled to have with me today on the Law Subscribe podcast, Laura Kennedy. Laura, welcome to the show.
Thanks, Matthew. It's nice to be here.
Well, I'm always trying to learn about new legal tech and just tech in general. And so I had heard, I think, Zen Case on Bob Ambrosi's podcast or something. So I figured, what the heck? I'm going to sign up for their newsletter, maybe attend some events. And the very first one that I attended was an event that you were doing, and you're talking about technology, and I love technology. And so let's just give a quick background for my audience if they haven't come across you before. Circle Management Group is the company, but why do you do what you do, and how did you end up doing it?
Well, it's a pretty short story. I've been a legal technology consultant now for almost 30 years. The Circle Management Group was founded in 2006, and prior to that, I was a solo. And now we have four partners and a team of anywhere between 25 and 30 people. I started out doing gemology, believe it or not. That was my birth love, teaching people about diamonds and gold and platinum and colored stones, and moved into teaching and did high school teaching and taught art for a while. Then moved into computers, and probably one of the first people in several school districts, K-12, to actually embrace technology. And so I was teaching kids how to use it. Then for 2 school districts in Missouri, I taught the teachers how to use the technology, which was a very interesting change from teaching college students about diamonds and platinum to teaching high school kids about art to teaching adults how to use a computer in the age of Windows 95.
For what it's worth, I used to be a camp counselor teaching 8-year-olds how to shoot a bow and arrow and hit a target. So, I feel like these are some of the things where if you could teach kids art or teach kids how to shoot a bow and arrow and hit a target, you could teach anything, right?
I did that for quite a few years. And then as the grant money ran out, they still wanted that same level of time from me. And I said, no, thanks. And I actually started working with a friend of mine who was a lawyer on time and billing products, and started doing that in the late 90s. And that is how I came into legal technology.
Wow. So you came into it as it relates to how lawyers make money and bill their time. That was your entryway.
Yeah.
Oh man. And so I got to imagine then that you've seen it all the highs and lows of billable time, and how lawyers are just terrible at tracking their time.
I've seen it all. I've seen everything. I think nothing surprises me anymore. Nothing shocks me. I used to be astounded, and now I'm not. So, it's just the way of the world.
Well, I will say I am still using, now I produce this podcast all on my own, and I am using skills taught to me by an English teacher from high school who thought it was important that we learn about technology.
Mm-hmm.
And so teachers teaching about technology is a super valuable thing, and that you were doing it when you were doing it was, I'm going to say visionary, just so you know, because because when I was in high school, I graduated in 2007, just to give people now everybody knows how old I am. I don't think I've ever disclosed that before, but in that time in the early aughts, iMovie had just been released, and my English teacher, Mrs. Brown, thought it was so important that we learn how to use these tools. She thought it was going to be the future, and this was before YouTube was even a thing.
Yeah.
So it's really something. So now getting back to your experience helping lawyers early on. So that one friend who became client, you just decided, okay, I like working with lawyers, and so you just continue to just work with lawyers. Why? We're a tough sell on anything. So why work with lawyers?
I don't know. It was just kind of the path that I took, and lawyers are interesting. They are there to do the best work that they can for their clients. Kind of like teachers, there's a higher thought process, a higher respect for humanity, I think mostly that lawyers have, same as educators. And so I think it was a natural progression for me in terms of the people that I wanted to work with every day.
Mhm.
I think lawyers as a whole tend to want to be the best that they can be for themselves, for their staff, or their clients. And that's what a teacher does every day. So like I said, side by side.
Right. So then I have to imagine that at least at the time that you got started helping lawyers, there were still a lot of paper timesheets. Is that true?
Oh yeah, little sheets of paper that they would write it on and stick it on a post. And then their legal assistant or their secretary would come and collect the post, pull the paper off, put the post back, and go to their desk and either type it into a Word document, type it into an Excel spreadsheet, type it on the typewriter, just depended on typewriters still existed back in those days. Lawyers and secretaries were afraid of them. And so they would do all of that. Or some of the more progressive lawyers would actually dictate their time.
Right. And I'll tell you what, lawyers are still dictating their time.
Yes, they are.
Yeah.
Except we get to use tools today like Theory and iPhone microphones and things like that for lawyers to dictate into their mobile apps and be able to do that. But yes, they still do.
Wow. Okay. So this is good. This is good to get this history lesson. So then the technology comes along. Well, even before then, like, so when you were getting started in the consulting of lawyers with time and billing, were you just helping like improve those very manual processes? Or were you, when you came in, you were like, no, we have to adopt some kind of technology here to speed up this process?
Well, it's interesting because when I came in, there were computers in the office. They were sporadic, and a lot of them were still DOS-based or Windows 3.1.1, which was still pretty DOSy, right? And there were very few programs that actually were available for lawyers to bill their time in. So the ones that had the computers and had the software were actually leaders in their world. And there were not very many case management software applications either to help with that. So I remember when one of the billing programs that we were working with went to a Windows platform, which was earth shattering, and people were freaking out because they had to move from a DOS-based system into a Windows system. I know this sounds so foreign, but it was really a big deal for these vendors to move to Windows.
It's foreign, but it's not, because with any large change, lawyers get very scared with any large change in technology. And it just sounds like it's always been the case. It's not unique to any generation of lawyers.
It is not. It's just whatever it was that they were doing before with technology or non-technology and having to move here. It's a scary proposition. And so my job is to help pave that way so that it's not such a scary thing for them to do. We're just not doing DOS to Windows anymore or WordPerfect to Word. We're doing, oh my gosh, we have to go to the cloud and we have to deal with AI and we're dealing with all of these new technologies. And it's very daunting and overwhelming to a lot of lawyers and to a lot of people, but especially, my focus being legal tech, it's a daunting proposition.
So I as much as I do want to keep going with the history lesson, and I may decide to go back to some of that, just based upon what you were just saying, like you're the trusted tech expert for the lawyers.
Mm-hmm.
So when AI hits the scene, I mean, and AI has been around, like e-discovery and like other things.
Been around for a long time. It's just not been like in your face prominent.
Right. But like Gen AI in particular and the natural language interface that, you have with it, I'm curious to know, well, first of all, you have to learn all these things. So I want to know what that's like, but I also want to know what it's like with, your long history of trying to get lawyers to adopt technology and learn technology and teach them technology, when now all they have to do is communicate with it like they communicate with any other human. And like what that difference looks like. And if they're still fighting it, even though it's like way easier to interface with Gen AI than any other kind of technology previously.
Well, I think they are, because I think that lawyers, when they're thinking through how to deal with a case, they're either wanting to talk to a colleague, or they want to dictate to their secretary, or they want to dictate into their dictaphone. They want to kind of pull their thoughts together in a different way. And this is a learned behavior. So talking The ones who are not going to adopt Gen AI are the ones that don't use Siri, they don't use Alexa, they don't trust the technology. And so it's an interesting conversation. And I think one of the things that starts with having the lawyers take that on is to give it purpose. And I've been working a lot with the vendors of the software applications to discuss ways to give AI purpose. What can they do with their software? How is it going to help them? I think I'm not a big fan of just opening up ChatGPT and asking it a question myself. I mean, I can, and I do from time to time, but I would much rather see AI go in and be able to have it do something that is meaningful to me. Have it generate a report, have it create a task list, have it do something, and have that AI integrated into the platform in such a way that it's much more productive.
Interesting. So the way you're saying how to use Gen AI is not treating it as a source of truth or an oracle, if you will.
Right.
Right. Which is the right way to use the tool,
right.
I think.
Exactly.
There are still lawyers at the time of recording. More lawyers have gotten in trouble for thinking that it's an oracle, that it's a source of truth, when that's not what it is.
Yeah, just check on the news lately, people. It's not a source of truth. It is not a place to go and have your kids go and get a history lesson. I don't think right now.
I don't think so. I don't think so. Like it is incredibly what at least mimics creativity, right? And it does a great job in analyzing and summarizing things you give it.
Correct. And I'm seeing a big push for the Gen AI to be not so global, but more centric into their firm and their firm's data, but using the tool, but keeping it so that it's not feeding the big artificial intelligence databases out there with, confidential information, attorney-client privilege. So really trying to keep it in-house and have it learn their data and their institutional knowledge and their documents and their processes and manage their, all of the things that have to do with the business of the firm.
Right. And all of these efficiencies lead to the death of the billable hour if it wasn't already on the chopping block. What are your thoughts on that progression?
So as a person who has to track billable time as well, because, you speak the language of your people. And so lawyers generally understand the value of the billable hour, even for us to do billing to them. They understand that it's a language that they embrace. So what happens then is we've been moving personally away from the billable hour and doing things more on a project basis and flat fee per task basis, task-based flat fees, sections of phasing bills as it, however you want to do it, which is really a lot of what I have seen. Even some of the e-billing platforms, the insurance companies are doing that same thing. They're going to let the lawyers track their time, but they're going to give them a budget not to exceed, which is basically the death of the billable hour because they have a cap, right? So they can track hours up to that cap. And so what happens with those situations then is we find more and more movement away from the billable hour because the clients that they're servicing also want to have some type of parameters around the time that's being spent on their cases. They don't want to just open up their checkbook and say, here you go, here's just do what you need to do. I think they're looking for boundaries on the lawyer's time, or actually not on the lawyer's time. They don't care how much time the lawyer spends. They want budgets around their costs.
Right. Pricing certainty has value to it on its own.
Right. And having some say in if they're going to go over that amount, having some conversation around that, why, having the lawyer communicate with them about the direction of their case, or why would we have to spend more money? Why are these things costing so much? And that type of conversation becomes this more centralized in the firm. And as that becomes more centralized in the firm, more and more attorneys are like, I don't know if we're going to keep doing the billable hour. Can we do some of these adjusted and alternative fee agreements with our clients? And they're starting to talk about it. It's a slow conversation, though. It's not something that is really prevalent out there with a lot of the attorneys who rely on that billable hour. I'm not seeing it in family law. I'm not seeing it in civil litigation when you have a high profile corporation that you're dealing with. Where I am seeing it, where it's been there for a long time, is in estate planning, elder law has a lot of that. Their clients are, trying to deal with things like Medicaid and Medicare. They don't have a ton of money, so they're trying to offer them services within a budget. Estate planning for sure. Seeing it more in business law and with opening corporations, doing corporate work, less hourly, more flat fee driven. Those types of legal tasks are being done more on flat fees than they are on hours.
I want to pull on a thread of something you said. You said lawyers are slow to have these conversations. And I wonder if they're so slow because they get paid the longer they work on stuff. So everything is slow to tech adoption, slow to alternative fee arrangement adoption, right? Everything's slow because why worry about efficiency when you make more money the longer things take? So, and even though we have our ethics, and I don't think I think some lawyers probably are, but I think most lawyers are probably not thinking, oh, I'm going to take my time on this because I'm going to make more money. I think that the incentives are just not there to, and you can move faster and not like super fast, and you could still ethically provide competent advice and do good work. It just doesn't need to be as slow and painstaking as it is.
I would say there's that, and there's also a lot of firms out there who are running on technology that is not an investment for the firm. When firms and law firms generally look at technology as an expense rather than an investment, they're running on old platforms, they're running on slow technology, they're running on things that are not going to give them any efficiency at all whatsoever. The first thing that has to change for a firm to become efficient is that they need to view technology as an investment. And when they do that, and they can actually visualize that the technology is going to help them make more money as opposed to not, instead of it, flying out of their own personal pockets, then there's a shift that happens where we can have those kinds of conversations.
Yeah, I think, though, that it's hard for lawyers to see that as an investment because especially if these tools, while they definitely get rid of non-billable time, they also tend to get rid of billable time or time that was like low-level work but still billable, that the lawyers have a hard time getting over because at least at first they see it's going to cut against their revenue. Now, I think that there is, and I've been going to ABA Tech Show for 14 years, so I know that these legal tech companies, they say, oh, well, there's going to be more billable work that you could do, higher value and all this stuff. And I think that's true for a while, but I think you get diminishing returns on that type of an argument. And eventually there's a tipping point where no, if you're still billing time, you're going to be losing money. And there's going to be more profitable ways to make money with alternative fee arrangements, right? And so I think that, and part of the reason, another reason I think, and I'm curious to get your perspective on this, is that lawyers see themselves as cost centers too to their clients a lot of times. They don't even look at themselves as I'm generating something valuable for my client because they're just like, how much time is it going to take? And now I'm going to charge my client that amount, and I'm a cost center to them. Whether they think about it in business terms like that or not, that's how their client sees it. That's how they're treating their own business. When they start thinking about what value am I providing to my client, and you get into that mindset where you mentioned the fixed fee stuff, that's that's a form of value-based pricing, right? What's the value of what I'm providing? If the insurance company has determined it's X amount of money, I don't want to have to track my time anymore. I want that exact amount of money, and I want to get to that end result as fast as possible to get there. It's an inverse relationship of time and money. So like once you abandon time equals money, and you think, this technology is going to make me more efficient, that means I make more money.
Well, it's a conundrum though, because from a pricing perspective, the only commodity that lawyers have is their time. And
I don't. Not me. I'm a subscription attorney. The less time I spend on something, the more clients I could serve and the more money I can make, the more automations I build, the more people could do it. My time is more valuable building a new automation than actually providing one-to-one synchronous legal services. So I think billable hour attorneys, yes, but I think it doesn't have to be that way. And that's why the podcast is trying to, you're right that a lot of lawyers think that way, but I think getting out of that mindset just completely opens up all the doors and makes you want to use all the technology that, Circle Management Group is going to help you use.
Right. So the conundrum is that for them to figure out what their value is, what to charge a client, there's a bridge that has to happen where they're tracking their billable time against their flat fee. So if they dip their toe in and they say, all right, well, this is a pretty complicated estate plan. So, I would want to charge $7,500 to do this estate plan for the client because it's that complicated. But I don't think that they're really going to pay that. So, there's this whole bargaining thing that goes on inside the mind of the attorney when they're starting these alternative fee arrangements. And so it's a learning process. So maybe you go a little lower, you track your time against it, and then you see, is this the right price? Is this the wrong price? And then you can start to place your value on that. And then as you become more efficient, you definitely don't lower your price, right? Because that investment pushes in.
Right.
And as you become more efficient, you become more valuable to your client because you can get it done faster, you can get it done better, and you can actually start to push your price up a little bit and begin to offset that investment. So as you invest here, you can begin to raise.
Absolutely right. And another thing that you could do, and one of the benefits I have of interviewing people on the podcast is they give me good ideas all the time. This is not one of my ideas, but this comes from a synthesis of a lot of past guests. But what you could do is you might think the client's only willing to pay this amount, but that's still you making a judgment call about you. Ask the client, hey, here, do you want this done in the next 6 months? It's, low price A. Or do you want it done in the next 3 months, mid price B? Or do you want it done tomorrow? Super high price, something that I can never bill the amount of hours and that they would ever pay this amount. Super, super high premium price C. And if they want it tomorrow, maybe they'll pay you $10,000 to do that, or $15,000 to get that estate planning done tomorrow that you would have charged $6,000 for at the low price, right? So asking your client, what do you value more? A cost savings, and we will get it done in time, or expediency, and you're willing to pay a premium for that. And I think that even asking your client, because a lot of lawyers, we think I have to decide what the price is and the client's going to pay that if they want my services, because that's how we've traditionally priced things, even with the billable hour. Right. But I think giving that option back to your client and just make up a big number that you never think they're going to agree to, but make it so they're going to get it tomorrow or in a couple of days. And we've had some guests on the show that have, I mean, it's all anecdotal, but they've said some clients pick that because a quick turnaround time matters more to them. And even if you were to bill every hour from now to tomorrow at your billable rate, you might have never made that amount of money.
Right. Well, it's that old adage, and I don't know if, the previous guests that you've had have put it in these terms, but this is just one of those things that we've said for the last 25 years that we've been doing this, which is good, fast, cheap, pick two.
Oh, yeah. Yeah. But let your client choose too.
Right. Exactly.
Don't you just choose the lawyer. Yeah. Let your client choose. And because if you want it to be cheap, it's not going to be fast, right? That's definitely not going to happen. Yeah. I like that phrasing. We might have heard some version of it, but I definitely like that. So then let's talk about, because at the Circle Management Group, you all are certified in all different kinds of pieces of technology. I recognize a lot of them, some of them specific to time billing, but some of them just these great tech platforms for lawyers to do a lot of stuff on. So are you seeing on any of these platforms where they're helping lawyers if they want to do alternative fees, this is built into the technology that's part of it, or are they more or less all just built around the billable hour, which is mostly what I see? When I went solo, I pivoted from mostly litigation to a transactional-only practice. I did not have a database of documents to automate. That's why a business and employment legal document database and automation tool like 650 is super useful. I can rely on the quality of the documents in 650's database since they're putting excellent legal minds to work curating and updating their documents and automations over time. When you're not billing by the hour, outsourcing and efficiency matters, and 650 can help you scale your practice to get high-quality documents drafted in less time. Use the code LAWSUBSCRIBED at 650.com, and when being onboarded to get 10% off. If you're not a business and employment attorney, or you have your own documents that you'd prefer to use, then my next sponsor, Gavel, is the automation tool for you. Gavel allows you to build shareable, client-facing workflow and document automations. In other words, Gavel helps you create a legal practice where attorneys can monetize the value they bring clients in productized form and scale via subscriptions and flat fees. Use the code LAWSUBSCRIBED at gavel.io to get 10% off an annual subscription. There's no one right way to automate and scale your practice, but with one or both of my sponsors, 650 and Gavel, you can take your subscription law firm to the next level. Links to both in the show notes. Now back to the show.
So I'm seeing a shift. So one of the things that I agree with, so I track a lot of things on Bob Ambrosie's site too, but I also track a lot of things on Gartner. And one of the things that Gartner was saying around the tech trends that are happening in 2024 is there's more of a project management focus in case management and matter management these days, as opposed to traditional practice management. Traditional practice management focused in on silos of information, in my opinion, contacts, matters, notes, phone calls, tasks, events, and that sort of capturing, automation to capture that time as you were doing it. So you would bill for the 0.22 that you did to open up this document and work on this document. And that was how the time capture was designed. The newer platforms, the more agile platforms, the ones that didn't grow up and their foundation in the 90s and the 2000s, the ones that are being developed now where the software is designed on platforms that are agile and the developers are younger attorneys, I would say, who are trying to solve a problem for themselves. These types of platforms now are very project management based. And what you're seeing is you're seeing budgets on tasks. You're saying, okay, this is what I'm budgeting. This is what I told the client I was going to budget. So they're tracking it by doing their work. And there's a big thing right now around passive timekeeping where it's tracking what you're doing behind the scenes. And the passive timekeeping, there's two types of it. I think there's the ones that just run on the computer and they track everything you do. Even if you go to a Google site or you're on Facebook for 10 minutes or whatever it is, it's tracking everything you're doing. Then there's the ones that are much more driven towards the work that you're doing within the system. And for those firms that are still on the billable hour, it gives you the opportunity to see what you did for the day. How you sent an email, you sent another email, you sent an email. It's tracking all of that, and it's creating a timesheet for the lawyer. It's tracking when the calendar event is passed and how long was the calendar event for. Did they complete a task? Did they enter a note? Those types of things are still valuable for some firms. But on the flip side of that, they are also offering the ability to do those alternative fee arrangements where you can bill against the budget. So when that task is complete, it will create the time entry against your budgeted amount as opposed to the amount of time that you did. So if you come across those time and billing arrangement products that have those types of automations in them, those are the ones that are going to move you along the spectrum of technology.
Mm-hmm. Yeah, as you were saying that, I was remembering how earlier you're talking about how you haven't yet come across like family law attorneys who are using billable hour models. We've had a few of them on the show, and I think jurisdiction does kind of matter and like what the legal ethics allow for. But I've only actually interviewed one. He only does civil litigation law, and he does it on pure subscription. Like he doesn't even do any hybrid subscription flat fee, which is what I tend to recommend, some kind of hybrid subscription flat fee, because you still have overscoping, underscoping problems. But he does a very particular kind of litigation. He has long-time relationships with his clients. He could ask his clients, what's your budget for this case for the next year? And he's like, okay, we're just going to divide that by 12. And I still think there are nuances to maybe you want a settlement success fee. Like if you settle it within so many months, you get a success fee. And then if it takes longer to settle it, that success fee goes down, to incentivize let's resolve this litigation sooner. So I still think there are ways to do a hybrid subscription flat fee. Some of these family law attorneys, they're doing segmented fees. And this is what I think this could be adapted to maybe more practice areas than just that pure subscription play that other attorney's doing. Brandon Harder, I want to say. His episode would not be live at the time we're interviewing, so you couldn't have even listened to it anyway. But so what these family law attorneys is they're doing segmented fees. So depending on the jurisdiction, they might have mandatory mediation or arbitration, right? So there's going to be a fee up to that point.
Right. I've seen a lot of that.
Right. So there's some flat fee type work there. But what we've been talking about a lot lately on the podcast and in when I do CLEs on this is even after the divorce, especially with family law, there's a lot of additional work alimony or maintenance or support, whatever it's called, child support, other compliance issues with the decree or the MSA. it's really easy to come up with a maintenance plan, or they pay you a monthly subscription, and maybe you have like mandatory quarterly check-ins with them, so you're at least earning your fee, because the ethics of earning a fee and not just paying it,
Right.
right? But then also, whenever an issue comes up, like that's either built into the subscription or it's an a la carte. Because you're subscribed, it's going to be this flat fee instead of maybe we used to bill by the hour to handle that kind of a thing, right? So I feel like there's a lot, and there's a lot of things. So criminal law, you're on probation. Okay, now there's our probation compliance subscription post whatever, right? And so I feel like there's opportunities, even with litigation, for anything like if it's post litigation, that there might be an ongoing subscription. Even when you brought up business law, like transactional, like the transaction is a project, right? They're buying a business, they're selling a business, they're setting up a business, whatever it is. Well, once that transaction is done, they have ongoing legal needs as a business, where the
Mhm.
subscription model comes in really well
Right.
for something like that. So I just think lawyers need to like open their minds to these kind of possibilities. And even if you were a family law attorney, you're like, I'm never doing the segmented flat fee, I'm just going to build time during the divorce. Well, maybe subscription will work really well for you, because you know what? That's your client might never come to you afterwards because they're worried the clock's going to start ticking. But if you offer them this simple, affordable maintenance package, that they could still ask you, hey, my ex-husband did this, or my ex-wife did that,
Yeah.
and you just want to ask your lawyer about it. Maybe they'd happily pay you $100 a month, or a few $100s a month, to be able to check in and ask you questions about that. I just like, I know you work with a lot of billable hour attorneys, Laura. So you tell me, you think any attorneys you work with would be open to something like that?
I think there are attorneys that are open to that. I think you made me think about you mentioned criminal lawyers, and they are the epitome of the flat fee attorneys, right? They're going to take that retainer up front. It goes into their operating account, and this is what it's going to be if up until the point where we go to trial. But if we go to trial, this is the charge, right? And that's how they function. They function like that for forever. Most criminal lawyers do. The I think there's some when we talk about the need to deal with that sort of information, though, one of the pushbacks that I get a lot from civil litigation attorneys is that they oftentimes will have to go to court to get their fee. And in order to go to court, they have to have an itemization of the work that they did for their clients, which, and the courts are still wanting to see things broken down into hours and rate and amount. So on the off chance that they have to do that, especially if they are prone to be one of the attorneys or firms that have to go after the attorney's fees in court, they're never going to move away from the billable hour, because they have to track it all.
I
Um,
think these passive time tracking tools that you mentioned, I think, would help with that,
right,
right? Because now you're not actually worried about tracking your time, because you're just trying to get the work done. But in the background, there's all these tech tools for lawyers now that passively track your time
correct,
in the background. And if you ever need that for a petition for fees, because the other side has to pay your legal fees, then I think that's where that's going to come into play. So I think that there's value to those tools, even though I think over time, as courts come around, I think those tools will be less
right,
and less useful. I mean, I don't know. Like when I'm at a CLE and we're talking about it, I get the question, well, should I still be tracking my time? And I've gotten exactly what you said, was like, well, what if I need to do a petition for fees? Well, in that instance, then maybe you do. But I said, if you're in a jurisdiction where the rules allow for fixed fees and flat fees, like Illinois, like we expressly allow it. So I don't need to, because I could point to the rules and say,
right,
I could charge this flat fee under Rule 1.5C. And so I
right,
do. And so here's my fee that I charge. And it's reasonable because of all these other reasons, right? And compared to the billable hour, it would have been 5 times as much. So it's definitely reasonable, court. You have to
right,
have the other side pay my fee. So otherwise they'd be paying more. Like, you're welcome on the other side. So it depends on the jurisdiction. But I think for those of the attorneys out there who are hesitant to stop tracking their time, I think the software that does the passive time tracking in the background, at least just to glance at it, because I would still encourage that they try to divorce the idea of time from money. But if you do, you could go back and look at it and see, like, but then it becomes the opposite. It's like, well, wow, doing that settlement negotiation took way more time than we anticipated. How could I speed that up? Like, it becomes the opposite, right? It's
right.
like, but tracking your time does help you do that. So even I'm open-minded enough to say, I think there is some value to using alternative fees and still being aware of how long things are taking, even if you're not billing that time out, kind of a thing.
Well, and not only that, but it does give you a record of the things that you did do on a case. if you're not of the mind that you're going to put the information into the system via a note, or you're going to save all the emails to the case, or you're going to enforce, gathering of all those communications, and I think the discipline of putting in the time entries is a way for the attorneys to record what they're doing on a case, and maintaining that record in case of a malpractice suit or something along those lines. They have that information, and time entries have historically been, this is what I did on your case, as opposed to tracking it through other record types associated with the case.
And I'm sure no lawyers have ever gone in and fudged that they did something. Oh, wait. I mean, because you run into that, that problem though too, is like a lawyer could always go back and fudge their time. And lawyers that are so bad at billing time, which we haven't really even talked about too much yet, is they're really bad at billing their time. The Clio Trends report basically shows that no lawyer likes to bill their time.
Sure.
They're at the end of the month, they're like, shoot, what did I work on? And they try to go back and they do the best job.
Look at their email. They go back and they look at their calendar. They go back and they look at their legal pads to figure out what they jotted down. I've been there. I've done that, trying to put together a bill for a client who was on an hourly agreement. I've had to go back and figure that out. And it's a time waste. It's a time suck. You lose a whole entire day doing nothing but recreating your timesheet for billing.
So it just costs you thousands of dollars to figure out how to make money. This is why the podcast exists, because I'm trying to get lawyers. Nobody likes to do it. I'm just saying there's a better way. Even Laura, you said you all are moving to value-based and project-based billing. Let me tell you, lawyers that don't want to learn technology and they just want to ask the consultant, there's a really good subscription model in there for you. I could see the potential for something like that with these law firms, right?
We have quite a few clients who do that. We have quite a few clients on a retainer.
Yeah.
And they have, well, there's several reasons. One is they have premium access to our consultants.
Right.
But they're on a retainer. It's like they go above the line, right? So there's a value to them, and not having to jump into a queue or wait to be serviced. And also it's a nice piece of cash flow, right? It keeps the business going, and there's a stability to that for the company.
Yeah, monthly recurring, annual recurring revenue. I mean, there's nothing better for a business, right? Especially if, and I have an interview later today. I don't know exactly when it's going to post in relation to this interview, but with Victoria Collier, she's all about buying and selling law firms. If you want to sell a business and you've got recurring revenue, you're going to be able to make a multiple on that you can't.
Absolutely. And that has been an ongoing conversation within our company for a long time, is you can't base your value on monthly revenue, because you never know how that's going to go. It's the client relationship that you build, and the monthly revenue that you can gain as a result of having that relationship with the client. It's a value win for both sides.
Right. And what I would suggest, because I have spoken with some lawyers who are like, well, I'm using a retainer, and they're using like an actual true to traditional retainer, not the retainer that they're billing against, which is like a more modern sort of take on that. Mm-hmm. And just reframe it. If it is truly like a month-to-month retainer, and it's not a retainer until you need me, which is also a different kind of retainer. You'd think retainer would mean one thing for legal services, but it means so many different things. If you have a recurring retainer based upon your availability to help clients with problems, whether you're a lawyer, consultant, whatever, if you reframe that as a subscription, and you reframe the scope of what you're giving as subscriber benefits, there's so much literature and resources out there about what you can do to improve that relationship with the business and the user, and what you can, and you start seeing all this other value that you could provide as a subscriber benefit. And you could even tier it, like even just a tier 1, tier 2 type of thing. Even Jess Birkin, I always go back to Jess Birkin. She was doing billable hours for nonprofits. She wanted to move to subscription. And whenever a new client came in, she said, here's the billable hour, here's the subscription, which one do you want to choose? So she just let her client choose. Right. And then like, here's all the subscriber benefits. Like, obviously she wanted her clients to pick the subscription. So it's like, look at all these subscriber benefits that you get when you subscribe at this level, this level, this level. Here's the billable hour where I do the work when you need the work to be done. And I don't know how much it's going to cost you every month. And so, which would you choose as a consumer? So
Yeah.
like, it's time that I think that we start to move to that, but we'll see. I also want to ask with the time we have left, like, have you mentioned the criminal attorneys, maybe you know some of them doing it, but have you seen any lawyers using alternative business models successfully, or any failures that maybe we could all learn from?
So I have a client up in the Northeast that is probably, I don't know, probably around 100 users up there, and they do a lot of healthcare law. And so they are successfully using the alternative fee agreements. They very rarely do an hourly agreement. And they're a really great client. And they have a great relationship with their employees and also with their clients. And one of the things that has really helped with that is they've been able to actually acquire some younger talent, because as a result of not being tied by the billable hour, they can bring on associates who are still dedicated to the work. But because they're not billing by the hour, there's not this heavy, oh my gosh, you have to put 100 hours in as an associate type of culture within the firm. The whole goal is to get the work done. And so what they have found is by doing these alternative fee agreements, they are actually having their attorneys work harder for them, because they have a more consistent way to look at the revenue coming into the firm for all of these different things. And so they can anticipate their bonus structure so much easier, because they have a sense of what the revenue is going to be as a result. So there's a whole lot of benefits for acquiring the younger talent to do it. And with that comes acquiring the technology to be able to do the drudge work, right? Not making associates sit and having to do document review for 100 hours in a week so that they can build up their billable hours, investing in the technology to be able to do that.
Yeah. Employee retention in the labor shortage that we have for like actual qualified licensed attorneys is huge benefit of alternative business model. And it sounds like for you love that client also because they probably love adopting technology. And it's
Well, I think they love adopting efficiency. There's a whole mindset that happens when the lights come on, and from a teacher perspective, which is, where my foundation is, when the managing partners all of a sudden have all those lights come on and they start to trigger through, oh my gosh, if we did this, and we did this, and we did this, how can we make this happen, Laura? It's a whole new way of doing business. And it makes me want to work hard for those clients, because they're not the ones calling in saying, my printer just crashed in the middle of printing bills. There's
right.
Don't print bills, email the bills. Why are you still printing bills? So there's
well, we have to print them so we could scan them, so I know where they are on my computer so that I could attach them to.
Right. There's
That
a whole
happens.
loss of efficiency over here. And these clients are much more exciting for my brain. And it keeps me fresh, and it keeps me moving, and it keeps me looking at better ways to make law firms effective and efficient and productive and profitable, and all the things that make me want to do what I do every day.
Right. Well, off call, you'll tell me who that firm is, and maybe I could reach out to them and have them on the podcast, because they sound like they'd be great for the podcast.
Yeah.
So with that, any other sort of things that you want to mention about technology and law? Any other like tips for lawyers listening in? Because a lot of my listeners, the bulk of my listeners are probably already bought into, I don't want to bill my time anymore. And maybe they've already moved away from it. But I definitely get new listeners all the time who are still billing their time. I think even just with that last conversation we had, I think that was a great reason for them to think about alternative fees. But whether we're talking about billing time or not, just like maybe some final tech tips for lawyers. What do you have for us?
So I think on a wrapping up note, invest in the technology, but invest in the technology with a purpose. Don't invest in the technology for the sake of saying that you have this app or that app, and don't invest in it because the law firm down the street uses it. that's not, may or may not be the right tech for you. You need to know what you have. You need to know what you need. Every firm is unique and has their own unique goals. So whether it is practice management, document management, time and billing, accounting, litigation support, email, e-discovery, whatever it is that you're looking, whatever problem you're trying to solve, identify the problem and the technology to do that. And I do not believe necessarily that lawyers themselves generally are any more equipped to pick out their technology themselves than I, as a consultant, am to go and represent myself in court. I think find a trusted advisor, find a consultant, get an assessment done, prepare the budget, solve the problems, and make sure you've got the right people in the right jobs to help you implement it. And do not skimp on training, ever skimp on training, because the worst thing you can do is invest in a piece of software that you're paying a subscription for monthly that nobody is using.
And for what it's worth, for one more argument to convince lawyers that they shouldn't be billing time is when you're not billing your time, it's easier to find time to do that training because you're not thinking this training is costing me a lot of money, because you're going to be making money when you're not actually working, because you've set up your business model so that it's either subscription or flat fee, and you've already got the money sitting in your operating agreement or trust account. And when that happens, you're going to it's easier to make time for training for technology.
Agreed. And it's interesting. One last thought. It's interesting when lawyers go there because all of a sudden they're calculating how much money they're losing as opposed to how much money they could potentially gain if they let everybody in the firm sit through those training sessions uninterrupted and actually learn the software.
Right. So with that, my last question I like to ask all my guests is a hot dog a sandwich, and why?
Well, I think it's a sandwich because it's a piece of meat in between two pieces of bread.
All right. If anyone wants to follow up with you or reach out, what's the best way for them to do that?
Call or text our office number 336-841-2187 or email clientsuccess@cmgconsultants.com.
All right, great. Laura Kennedy, thanks so much for coming on the show.
Thanks for having me, Matthew.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn, since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.